Whereas with the inauguration of the new constitution for the whole of India now being framed by the Constituent Assembly of India, the Government of India Act 1935, which now governs the constitutional relationship between this state and the Dominion of India, will stand repealed. And whereas in the best interest of this state, which is closely linked with the rest of India by a community of interest in the economic, political, and other fields, it is desirable that the constitutional relationship established between the state and the Dominion of India should be continued as between the state and the contemplated Union of India, and the Constitution of India as drafted by the Constituent Assembly of India, which includes duly appointed representatives of the state, provides a suitable basis for doing so. I now hereby declare and direct that the Constitution of India, shortly to be adopted by the Constituent Assembly of India, shall, in so far as Jammu and Kashmir, govern the constitutional relationship between this state and the contemplated Union of India, and shall be enforced in this state by me, my heirs and successors, in accordance with the tenor of its provisions, that the provisions of the said Constitution shall, as from the date of its commencement, supersede and abrogate all of the constitutional provisions inconsistent therewith which are at present in force in the state. Now, my lords, therefore, it was understood that on the enforcement of the Constitution of India, my lord, which took place on 26/1/1950, there is no residuary sovereignty that is retained, my lord, by the treated as a Part B state. The provisions of the Constitution are made applicable to the Union of India, including the state of Jammu and Kashmir, with effect from the date of enforcement, that is, my lord, on 26/1/1950, when the Constitution commences. It is, my lord, difficult to countenance an argument, my lord, this I say so with greatest respect, that there was any sovereignty, which whether you call it as residuary, internal, as distinguished from external sovereignty, which survives, my lords, the enforcement of the Constitution of India with effect from 26/1/1950, when, after, my lord, the Yuvraj had also made it clear and had declared that the relationship between the state and the union will now be governed by the provisions of the Indian Constitution, which means that we don't have anything more. There were 4 representatives from the state of Jammu and Kashmir earlier in the Constituent Assembly. We have gone through each clause, and we have ultimately looked at 370 also, which is an integral part of the Constitution, which is also a part of the Constitution. And we have therefore decided that we will abide by this. Now, my lords, the question of if this is the integration, therefore becomes complete, my lord, on enforcement of the Constitution, there is nothing residuary about. Now, if your lordships kindly have a look at, my lord, I am sorry, but then to make my submission, my lord, on the question of, my lord, what therefore survives under 3, what therefore survives, my lord, will also have to be looked into in Article 370 and 373, and there is nothing more, my lord, which can be read into it. There is nothing in the Constitution of India, my lord, which carves out an exception in the case of state of Jammu and Kashmir, both as regards the sovereignty, any sovereignty, other than, my lord, Article 370 itself. And 370, in my respectful submission, does not indicate that there is any residuary sovereignty that is left with the state of Jammu and Kashmir. It becomes a part of the Union of India. My lord, the enforcement of Article 370 also, and powers exercised by the President from time to time in issuing a constitutional order, is also an exercise of a power that is conferred, my lord, under the Constitution of India. It is nowhere else. President doesn't go outside the bounds of the Constitution. And therefore, my lord, if abrogation of 370, which would result, my lord, in the effacement of any special status that is given to the state of Jammu and Kashmir, is inbuilt into Article 370, and it is also within the knowledge of, my lord, the sovereign in the state of Jammu and Kashmir, my lord, prior to the enforcement of the Constitution, to say that I still retain some residuary sovereignty with me in spite of the enforcement of the Constitution after 26/1/1950, not reflected in Article 370, not reflected in any other provision of the Constitution of India. My lord, it's not a submission that would be countenanced by your lordships. But what are the petitioners asking for? Petitioners, my lord, say the 370, which is a temporary provision, must be treated as a permanent part of the Constitution. What form? If, my lords, is it for the purpose of, my lord, claiming for expansion of any right? Apparently not. No, my lord, because once the 370 goes, and, my lord, Jammu and Kashmir, my lord, therefore, the integration is complete even when the enforcement of the Constitution takes place. My lord, the insignia of any sovereignty is a lawmaking power. One of the insignia is a lawmaking power. That's, my lord, the lawmaking power, my lord, has been with the union and with the states, my lord, in list 2 and list 3 also. Unless, my lord, the parliament by an overarching, resort to the provisions, my lord, of lawmaking power in the list 3 also supersedes the legislation that is prevailing in the state. If, my lord, it completely therefore applies after Article 370 is abrogated, isn't there an expansion of the right, my lord, that is available to any person who says that I am a resident in the state of Jammu and Kashmir? I therefore belong to that state. I also belong to the Union of India. But therefore, my lord, what is the abridgment of the right, my lord, that the petitioners are really concerned about? No, my lords, insofar as abrogation of 370 is concerned, when the lordships would have noted that sub-article 3 was also therefore part of, my lord, in the manner in which it was framed even before 1950. I mean, on 26/1/1950, my lord, this is how it looked at. And that was at a point of time when the Constituent Assembly for the state was yet to be convened. It was convened later, my lord, in January 1951. Now, if your lordships kindly come to that for a moment. There are two places, my lord, where the Constituent Assembly for the state is referred to. Firstly, my lord, in sub-article 2, but please come to sub-article 3. Notwithstanding anything in the foregoing provisions of this article, the President may by public notification declare that this article shall cease to be operative or shall be operative only with such exceptions and modifications and from such date as he may specify. Provided that the recommendation of the Constituent Assembly of the state referred to in clause 2 shall be necessary before the President issues such a notification. My lord, the crucial words are recommendation of the Constituent Assembly of the state referred to in clause 2. My lord, in clause 2, the reference to the Constituent Assembly is qualified by certain words, my lord. If the concurrence of the government of the state referred to in paragraph 2 of subclause B of clause 1 or in the second proviso to subclause D of that clause be given before the Constituent Assembly, my lord, please permit me to read it slowly. For the purpose of framing the constitution of the state is convened. Therefore, my lord, it was understood that a Constituent Assembly will be convened for the purpose of framing the Constitution of India, as originally contemplated in Article 370 itself. But this Constituent Assembly is only for the purpose of framing the Constitution of the state. And, my lord, it is a fact which is accomplished that on framing the Constitution for the state, my lord, it dissolved itself. That it will be convened for a specific purpose and that it will dissolve itself were also matters within the knowledge of the framers of the Constitution even then. And then, my lord, therefore, in proviso, when they refer to the Constituent Assembly for the state, there was a terminus acto, my lord, for the Constituent Assembly, which was within the knowledge, my lord, of the framers, and therefore that is what is referred to in the proviso. My lord, it could not have been contemplated that the Constituent, it was, or rather, my lord, let me put it this way. It was, my lord, it was concluded, or it was definitely, my lord, the intention that the Constituent Assembly for the state, which is convened for the purpose of framing the Constitution of the state, will have a natural death, my lord, when the Constitution for the state is framed. But when they say, my lord, that the recommendation of the Constituent Assembly for the state shall be necessary before the President issues such a notification, did they not have in mind that the recommendatory powers are therefore coterminous with the tenure of the Constituent Assembly, which has to end, my lord, with the framing of the Constitution for the state? It is not as if, my lord, the Constitution contemplates a Constituent Assembly for any purpose other than the framing of the Constitution for the state as such. Therefore, my lords, one of the termini which your lordships were referring to, there are two terminus echo, my lord, insofar as the Constituent Assembly is concerned, going by sub-article 2 and the proviso. One is the convening of the Constituent Assembly, and the other is the dissolution of the Constituent Assembly. The proviso merely does not say Constituent Assembly of the state. It says Constituent Assembly of the state referred to in clause 2. Clause 2 says Constituent Assembly for the purpose of framing the Constitution. Therefore, the tenure of the Constituent Assembly is inbuilt, my lord, into sub-article 2 and the proviso as well. If therefore, my lord, the triggering factor as per the proviso to Article 373 for the President to issue a public notification either abrogating it or, my lord, declaring that it will be operative only with such exceptions and modifications is a recommendation of the Constituent Assembly of the state referred to in clause 2. It has to be inferred, in my respectful submission, that the triggering factor would be alive and operative only till such time as the Constituent Assembly is alive. And this is an inference, my lord, which I beg to infer and which I commend for your lordship's acceptance, is inbuilt into sub-article 2 and the proviso. That's why, my lord, the crucial words Constituent Assembly of the state referred to in clause 2 need not have been that way. But when sub-article 2 says before the Constituent Assembly for the purpose of framing the Constitution of India, therefore, my lord, even originally it was contemplated that this Constituent Assembly for the state will have no function other than, my lord, or will be functus officio once the Constituent Assembly of the Constitution of the state is convened. That, my lord, it's a historically recognized fact that it actually dissolved itself in 1957 itself. But that's a different matter. But the point is, my lord, for the purpose of the proviso, the triggering factor, my lord, is contemplated as being available coterminous with the life of the Constituent Assembly referred to in sub-article 2, and therefore, my lord, it ceases to have any significance, my lord, once the Constituent Assembly is dissolved and once the Constitution of the state is formed. But, my lord, it cannot, under any interpretative tool, give fodder to a submission that Article 370 as a whole, and at any rate Article 370 sub-article 3, would also cease to be operative once a proviso becomes inoperative. My lord, ideally, my lord, the proviso could have been deleted after the dissolution of the Constituent Assembly for the state. That's a different matter, my lord. One need not get into that hypothesis at all. But it cannot be contended that the power of the President vouchsafed under Article 373 would cease to be available because the proviso is no longer available to be operated upon. In my respectful submission, the proviso itself contemplates that the recommendatory power of the Constituent Assembly, my lord, whatever is the content of the recommendatory power or not, my lord, it's a different matter. I think enough submissions have been made on that. But the recommendatory power of the Constituent Assembly was intended even originally to be coterminous with the life of the Constituent Assembly, which anyway, my lord, was dissolved after the Constitution of the state was convened. My lord, my written submissions are at pages 400 to 411, my lord, of volume 3. 401 to 411 of volume 3. 411 to 401 to 411. My lord, this aspect has been dealt with, my lord. I won't therefore take up more time of your lordships on this aspect. My lord, paragraphs 1 to 4 I have dealt with this. My lord, the next submission, my lord, would be on the aspect of federalism. My lord, there are two, my lord, papers, my lord, which your lordships may kindly have a look at, juxtaposed with each other. My lord, one is the opening remarks of Dr. Ambedkar, my lord, which your lordships will find in volume 8 of the compilation of documents.
Okay.
Sorry.
If you're beginning a new point on federalism, should we take it up on Monday?
Very well.
So that.
Very well. Lord, I'll still maintain the timeline.
We are always conscious of how you are generally in the court, so we don't expect anything different. You'll be precise and always very focused. We expect that as usual.
I'm great.
Thank you.
My lord, there was one request, my lord, lordship, if your lordships could consider, because it fell from your lordships, my lord, would it be possible for your lordships to convene at 10 o'clock on Monday so that we get 3 hours?
Lord, Mr. Nataraj had, my lord, 10 minutes of submissions. A new point.
Their circumstance for today, and we have given you full half day now.
Very good.
You've
Lord,
got a half day more.
No, Mr. Nataraj would like to have 10 minutes. And two other people who will, I know your lordships would not.
We'll come back.
Then
All the
Mr.
young, not so young can divide the time period between 10:30 and 1.
10:31. At the same time, I know that everybody has worked very hard. We wouldn't want to
Therefore,
deprive
some
even at
of
least
them
5
have-
minutes of time.
Lord, some of them have worked since 10 years. Let them have, my lord, their day in the court, my lord, maybe for some time.
I'm sure that the seniors who precede them will give them some time so that they have that
No,
time.
we'll do that.
Certainly.
For example, Mr. Tanwani is also a research scholar.
Who?
Mr. Tanwani, Mr. Rahul Tanwani has been
Tanwani, Mr. Rajput, they have been working since many years.
Will certainly give them
Whatever
some
they
time.
can contribute.
Told Mr. Tanwani that some of the points I want to make, I will keep for him.
I'm sure you'll be able to.
We'll do that. We'll do that. We won't exceed the time. We'll finish by Monday, 1 o'clock or whatever is the time that your lordships are.
1 o'clock.
So we'll wrap it up on Monday for this side at 1 o'clock, and then in the afternoon we'll start the rejoin.
Very good.
Grateful.
Grateful to you.